working on that stuff. I did not go last week, and we'll probably not go this week. Wow. I know, just a little busy. Yeah, Thursday. Yeah, I didn't realize that. And so, it's Juneteenth. Well, it doesn't seem like it should be even June, because it's so bad. They don't. Oh, is it just county? And federal. But it's also a federal holiday.
Yes. Well, it's kind of cool. They might open that because they don't have fast.
Yes, I was thinking this was like, what is it, Confederate Memorial Day is a state holiday, so you can't go to judge or a court reporter. But it's not like a county holiday. They should just take that one away and replace it with something else. Like maybe President's Day. I remember when that did that.
Let's just have an all day.
bring the jury in.
Your Honor, just as a housekeeping matter, we went over the exhibits with the court reporter. 99A through J, she does not have specifically admitted, but she does show that Your Honor allowed us to publish them, so I would just ask that they be formally admitted. This was where we had 99A through J and 99A2 through J2. It would have been during Lieutenant Wells' testimony on Friday.
I've got 99, got admitted into evidence over defendant's objection, 99A2 through 99J2 admitted into evidence without objection.
So it may have just been that I wasn't clear. As I said, in that case, this was, I believe, the H-Gabe email. And so 99 was the portion of the report that showed the H-Gabe email. 99A through J would have been the images. Let me just double check that.
Yeah, I don't have 99A through J. I've got 99A2 through 99J2.
Right, and so again, I probably just was not clear when I spoke. I handed Lieutenant Wells both 99A through J and 99A2 through 99J2, and we went through them at the same time. So 99A was the IMGDB image from the H-Gabe email, and then 99A2 was showing that that image had been cached on the defendant's phone prior to the email being sent.
So you're seeking to admit now 99A
A through J.
Through J.
Yes, Your Honor. And I believe we did go through them at the bench.
And all of this is part of State's Exhibit
99.
99.
Yes, so in 99, Your Honor, you can see smaller versions of the images. So then Lieutenant Wells testified that he went to that image and then was able to show that image on the defendant's phone.
All right, what's the defense position?
Your Honor, we objected to them as they were coming in. Whatever the record shows, Your Honor, the record shows they're not in. They're not in.
Okay. All right, I'm going to admit State's Exhibits 99A through 99J. Since State's Exhibits 99 is already admitted into evidence, and these are just a portion of that.
Yes.
Good, okay.
And then, Your Honor, there's some question as to 62 and 63. The state shows that they were admitted during Detective Edwards' testimony. Those are discs of the surveillance from Lowe's. So it would have been the point of sale surveillance and the parking lot video.
During whose testimony?
Detective Drew Edwards. I think he would have been Wednesday.
He was.
I believe he was Wednesday.
You're talking about defendant's exhibits what?
State's Exhibits 62 and 63.
Yeah, they were never put in. What's the defense position?
It's fine, Your Honor. If they're not in it, I don't believe we.
There was marked for identification, never admitted in evidence. What's the defense position?
Whatever the record shows, you know.
All right. State's Exhibits 62 and 63, they weren't put in. I'm not going to put them in.
That's fine, Your Honor.
All right, anything else from the state?
Nothing from the state, Your Honor.
Anything from the defense? Will we bring the jury in?
Nothing for the defense, Your Honor.
All right, let's bring the jury in. Ladies and gentlemen, welcome back. Hope everyone had a good weekend. Hope everyone had a good Father's Day. We're ready to resume with the trial of this case. Please make sure you have your own notepads and no one else's notepads. State and call your next witness.
Your Honor, at this time the state rests.
All right, ladies and gentlemen, the state has rested their case, and now is the time of the trial where I have to take up some matters of law with the defendant, with the parties, the state and the defense. As I told you earlier, when we discuss the law, it often requires us to reference factual issues, and we don't want you to be influenced by anything that I say or the attorneys say. So I'm going to excuse you back to the jury room for just a few minutes, and we'll bring you back out in just a second. All right, any motions?
Your Honor, we move for a directed verdict on the conspiracy charge. Testimony in the case from all witnesses is that there was no agreement between Jackson and Mr. Dontell. Of course, that's required for a conspiracy charge. He testified very forcefully. He knew nothing about it, had nothing to do with it, hadn't agreed to anything. So, under the facts and the law, that charge should be dismissed.
All right, the state's position.
Your Honor, we would ask that you deny the defense motion. In order for a directed verdict to be granted, there must be a failure of competent evidence. And in this case, we believe that there is ample evidence that the defendant and Mr. Dontell acted together. We believe that the conspiracy continued through the disposal of Mr. Rice's body. Certainly there is evidence that they went to the preserve on the 29th, the 30th, and the day that Mr. Rice was murdered to engage in target practice. There was a text message indicating the defendant, I believe, said, "I'm all for popping a tire now." And Mr. Dontell said, "I agree." I believe that's a question for the jury.
So you're saying Mr. Dontell lied on the stand when he said he didn't know anything about it, she jumped out and started shooting?
No, Your Honor. I believe that the way his testimony came across was that he thought she was kidding, and he actually testified at one point. She said, "I hate my kids, I hate my mother, I hate this person, I hate that person." But the conspiracy certainly lasts through putting Mr. Rice's body in the back of the van, storing him at the Myrtle Beach Funeral Home, and disposing of his body.
No, conspiracy is a pre-arranged plan prior to the act. Disposing of the body is the accessory after the fact. Conspiracy, you have to have a pre-arranged plan between two or more people to commit the crime, and that they actually carry out that crime pursuant to the pre-arranged plan. What evidence do you have that there is a pre-arranged plan between this defendant and anybody else to commit murder?
Your Honor, I would just point to the evidence that I've already highlighted, but I will leave it in the court's discretion, certainly.
All right, I'm going to grant the motion as to the conspiracy charge. I don't see where the state has presented any evidence of a prearranged plan between this defendant and any other person to commit the crime.
Your Honor, on the remaining charge of murder, as I understand it, that would be the only charge
That's correct.
remains.
That's correct.
We would like to have that dismissed also based on this theory that the reliability of Mr. Dontell is so flawed. Even as prosecutors brought out, he lied many times. He returned, he said he was afraid, he admits returning to his relationship with Ms. Jackson. So our position is no reasonable jury could find there was murder here because they would have to believe Dontell. And his testimony is so flawed that that wouldn't be a just verdict.
All right, I'm going to deny the motion. I think the fact that he has testified at least creates a jury question as to whether or not he's believable or not. So I'm going to deny that motion. All right, any other motions?
That's all from the defense, Your Honor.
All right, do we want to go ahead and let me question your client on her right to testify?
Yes, sir, Your Honor.
All right, and if I could get you to stand and raise your right hand, please. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right. Your name is Meagan Marie Jackson.
Yes.
All right, Ms. Jackson, at this time, I'm going to explain to you certain rights that you have. If you do not understand anything I say, please let me know. And if you want me to explain anything in more detail, please let me know. You understand that?
Yes.
All right. We've now reached the stage of the trial where you may present your defense. You have the right to claim the protections given to you by the Fifth Amendment to the Constitution of the United States. This amendment states in part that no person shall be compelled in any criminal case to be a witness against himself. This means that you cannot be required to testify in this case. You have the right to testify on your behalf. However, no one can make you testify. This is a personal right, and no one can waive this right except for you. If you decide to testify, you will be subject to the same rules that govern other witnesses, and you may be questioned and examined and cross-examined on any relevant issue in this case. In addition, if you have any convictions involving dishonesty or false statement or for crimes punishable by imprisonment for more than 1 year, and this court determines that the probative value of admitting this evidence outweighs its prejudicial effect to you, the solicitor will be able to introduce your record to attack your credibility. Now, are there any prior?
No, Your Honor.
All right. If you decide to testify, this decision on your part must be freely, voluntarily, and intelligently made with the knowledge of the protections given to you by the Fifth Amendment to the United States Constitution and the consequences of your decision to testify. If you decide not to testify, I will instruct the jurors that they cannot give the fact that you did not testify any consideration whatsoever, and that there is to be absolutely no prejudice to you because you did not testify. It's left entirely up to you whether or not you testify. You may talk with your attorney, your friends and family, or anyone else, but the final decision will be left entirely up to you. Now, do you understand what I've explained to you?
I do.
Do you have any questions about what I've explained to you?
No, sir.
Have you discussed with your attorneys whether or not you should testify in this case?
Yes, sir.
All right, do you feel like you need to talk to your attorneys anymore about this issue?
No, Your Honor.
All right, is there anybody you feel like you should talk to about this issue before making a decision?
No, sir.
Have you made a decision as to whether or not you wish to testify in this case?
Yes, sir.
And do you wish to testify in this case?
No, Your Honor.
All right, and is this your decision?
Yes, sir.
All right. Anything further the defense wants on the record regarding the defendant's right to testify?
No, sir, Your Honor. We talked to our client thoroughly about her right to testify, as have you, and this is her decision, and we stand by her.
All right. Anything further the state wants on the record regarding the defendant's right to testify?
No, Your Honor.
All right. Will the defense be putting up any other witnesses or any other defense in this case?
No, sir.
No, sir.
All right, so I guess all we have now is closing arguments, charges, and deliberations.
Yes, Your Honor.
All right, let's take about, I've got some of the charges done. It's probably going to take me about another 30 minutes. I'll finish up the charges and get you a copy. You can take a look at it. You can do one of two things. If you want to submit something, you can submit something. If you want to wait and get my proposed charges, review them and see if you have any objections or additions, then you can do that as well. Okay?
Thank
Your
you.
Honor,
Yes, sir.
quick question. There was discussion about charging the jury before and then closing, or closing and then charging.
Right.
We would prefer you charge before. I didn't know if the state had any preference, or if you had any preference, Your Honor.
Well, I generally charge after unless both sides agree. So
That's fine, Your Honor,
What is
and
the state?
whatever the state would like, that's
We
fine.
prefer after, Your Honor.
okay, I'll charge after.
That's fine, Your Honor.
So, in the closing argument, since the defense has not put up anything, the state will close in full,
Yes.
then the defense will close in full. And
Yes.
that'll be all of the closing arguments.
Thank you, Your Honor.
All right, let's take about a 30-minute break, and we'll come back. Okay? Yes, sir.
Let me ask this, we're concerned about one charge you're going to be asked to give, which is hand of one is hand of all. We'd like to be able to address that before we make our argument.
All right. All right. Well, let's go over that now. Is there a hand of one? I mean, you're saying she committed the act. So what evidence is there that Mr. Dontell committed the act and she was there aiding and assisting in the commission of that?
Well, Your Honor, without being able to read the defense's mind, I'm sure they are going to say that Dontell is the one who killed Mr. Rice.
I'm sure they are.
Therefore, the presence of both the defendant and Mr. Dontell throughout the night, including going to the preserve, it's up to the jury to decide whether or not they were acting together for hand of one, hand of all, but I certainly think that there's enough evidence in the record with them being together the entire night. Dontell actually driving Ms. Jackson's van to the location, helping to load Mr. Rice's body into the back of the van, again, all the way through disposing of the body. It's up to the jury to decide whether or not Mr. Dontell knew what was going to happen or not. I believe that that's a question of fact for the jury.
But the question is, for this defendant to be guilty under the theory the hand of one is the hand of all, you have to have Mr. Dontell committing the crime and her there aiding and assisting in the commission of the crime. If you have her committing the crime, it's not the hand of one, unless it would be Mr. Dontell guilty under that. A hand of one is the hand of all, is that you are there aiding and assisting someone else in the commission of the crime.
But again, Your Honor, if we're trying to forecast the defense argument, it is likely, I would think, that they argue that Mr. Dontell pulled the trigger. It is therefore up to the jury to decide either way. They can believe all of his testimony, none of his testimony, or part of his testimony. So it would certainly be within the jury's purview to say, well, we believe most of what he said, but we think he pulled the trigger and not her.
Well, what I'm saying is, what evidence has the state presented that he did pull the trigger and she was there aiding and assisting him? That's the hand of one is the hand of all. What has the state presented in its case in chief that shows Mr. Dontell committed this crime and that she is guilty as a principal because she was there aiding and assisting him in the completion of the crime?
I think that given the fact that the jury can believe all, some, or nothing from Mr. Dontell's testimony opens that possibility that he is the one, again, as I'm sure the defense is going to argue, that he is the one who fired the gun and not Ms. Jackson.
What evidence do you have that he is the one that fired the gun?
we don't believe that he is the one, but certainly there is that possibility within his testimony if the jury believes only part of what he said.
Your Honor.
Your Honor, I'd like an opportunity then to do more research if Your Honor
Yeah,
is
let's do
considering
some
that.
research on it, and if there's anything in the record, anything in the evidence that goes to the jury that shows Mr. Dontell is the one that committed the murder, and that Ms. Jackson was there aiding, assisting in the completion or the commission of that crime, then you've got the hand of one that's the hand of all. But as I look back, I'll look back over my notes, I don't know that I recall the state putting up anything that shows Mr. Dontell is the one who committed the crime. Now, they can argue that, but I don't know that there's anything in the record from the state that shows Mr. Dontell as the trigger person, so to speak. I'll look back over my notes, you do your research, and we'll come back and readdress it.
Thank you, Your Honor.
All right, thanks. Let's take about a 30-minute break. Ladies and gentlemen, I'll give you two opportunities to raise an objection to the charges or request additional charges. One is now, and then another one is after I charge the jury. Because sometimes it does sound differently when you hear it's charged orally versus reading it on a sheet of paper. Now, before we go forward, I did include the hand of one as the hand of all. As I look back over my notes, recall the testimony, the fact that under Mr. Dontell's examination, it came out that he was charged with murder and conspiracy, and that he worked out a deal in January, I think it was January when this case was called for trial, whenever his case was called. I think that creates evidence that, yes, he may have been the one that actually pulled the trigger, and therefore the hand of one is the hand of all, that she was acting with him. The fact that that came out during his testimony does show that there is some evidence there where a jury could believe that, yes, he's the one that committed the crime as the actual perpetrator. That's why I included it in. Anything from the state?
Nothing from the state, Your Honor.
Anything from the defense?
Yeah, respectfully, we maintain our disagreement with court on handling one and of all. There's no reason to argue that anymore.
I understand. And your objection's on the record, and before I started reviewing notes and going over the charge of the hand of one is the hand of all, I was inclined to agree with you, but then I do recall Mr. Dontell's testimony where he was charged as the principal, and then the day of his trial, he made the deal with the state and pled to accessory after the fact. So I think there is evidence there that he committed the crime, and she was acting. And that's the reason I want to get on the record, the reason for my decision. All right, anything from the state before we bring the jury in?
Your Honor, if I can just have a moment, I was waiting for the final ruling to make sure I didn't need to make any adjustments to my PowerPoint, so I just need Ms. Dean to set it up.
That'd be fine. That'd be fine. Oh, and she can go ahead and do this. I'll do however y'all want to do, since it's just one indictment and it's going to be just guilty or not guilty. Typically on that, I just send the indictment, let them write the verdict on the indictment, rather than, there's no lesser included offenses or anything where I need to do a verdict form. Is that all right, Mr. Say?
It's fine with the state, Your Honor.
All right.
That's fine, Your Honor.
Okay.
Because it's just the state version.
I guess when we bring the jury in, if the state is rested, I'll ask the defense, is there anything you can say the defense rests?
Yes, sir, Your Honor.
Yeah, we rest, Your Honor.
All right.
Yes, sir,
But
Your
I'll
Honor.
let you rest on the record in front of you.
Yes, sir, Your Honor. Thank you.
Your Honor, I'm sorry, if the defense is going to renew their motions after they rest, would it make sense to argue them now rather than
Well-
having the jury come in and out?
And I never really understood that. I don't know if they can make motions after they rest when they don't present
Right.
anything, because there's nothing new
Different.
presented, and I think their motions and objections are already served.
Okay, I wanted to avoid them coming in and out.
All right, anything from the defense before we bring the jury in?
I believe, Your Honor, that would do it if we're going to be done with arguments. We just have our objection to the one hand wall, which is noted. Besides that, Your Honor, I think we're ready to proceed.
All right, let's go ahead and bring the jury in. All right, ladies and gentlemen, welcome back. Please make sure you have your own notepads and no one else's notepads. The state has rested their case. The defense which is presented today.
Your Honor, the defense rests.
All right. Ladies and gentlemen, the defense has rested their case. So all the evidence has been presented to you, and now is the time of the trial where the attorneys will make their closing arguments to you. Now, just like their opening statements, these closing arguments are not evidence. It is simply the attorney's contention as to what they think the evidence has shown and the law to be applied in this case. If at any time an attorney references a factual issue that is different from the facts as you find them to be, or references the law that is different from the law as I will charge you at the close of their arguments, then you're to disregard that portion of their arguments, because this is not evidence and it's not a charge on the law. It is just the attorney's contention as to what they think the evidence has shown and the law to be applied. All right, state wish to close?
May it please the court.
Yes, ma'am.
This is a tale as old as time, as you were told in the opening. It involved an affair, a pregnancy, and a murder. But there was a fourth aspect of this case that is equally as important, and that's deception. The defendant was the center of the affair, certainly the pregnancy, and most definitely the murder. But the evidence has also shown that she was the center of the deception. In fact, she is a master of deception. I guess the correct term would be mistress of deception, but master of deception is a little bit more common. As you learned during the trial, the defendant and the victim had 4 children together. You actually heard from their oldest child. And think of the strength that that took Savannah to come in and testify against her mother in the murder of her father. They had 4 children, but they had been separated for about 10 months to a year before Greg Rice was murdered. They still had that connection of children, as you always do when you share children with someone else. And as you review the exhibits, because you'll get to bring them back into the jury room with you, you will see that their conversations were mainly about the children, about Greg wanting to pick up the children. When can he see them? So that was the tie that bound them together. The defendant, meanwhile, was involved in body transports. She comes into contact with Christopher Dontell during the course of her work, and she sets her sights on him for some reason. She begins to show up at his favorite restaurant. She ingratiates herself to him, and they begin an affair. She infiltrates the Dontells' marriage and life. She moves to their community. She showers them with gifts. She and her children spend, this was COVID. Erica Dontell testified that they spent almost all the time together, her family and his family. And then she began to spin her web of lies because she wanted to destroy the Dontells' marriage. But she also wanted to get rid of Greg. And so she started to frame him for revealing information about the affair. You may recall that during the trip to Florida, that was the defendant, Mr. Dontell, Savannah, and one of Savannah's friends, the defendant showed Dontell one text message. All I can say is wait for the storm. And based on this text message, she told Dontell that she was terrified of the victim. Didn't want to be near him. He was hell-bent on hurting her. You have to come with me. I'm going to confront him, but you need to be there because he is going to hurt me. Remember, all I can say is wait for the storm. But, and I know it took a little bit for Lieutenant Wells to read through that whole conversation, but especially here, the context of that one text is extremely important because you should recall, and again, you will have the exhibit in your room with you, that the conversation was about the children. Greg did not know that the defendant and Dontell were in Florida. He thought they were in Ohio. He was caring for the other 3 children, and the defendant had stayed away longer than she had told him she would. And his job was suffering as a result. He couldn't work because he had to care for the children. And so that's what he continually caught her in lies. You told me you were going to be home yesterday. You told me you had a court date. I'm tired of all these lies. So the storm was to expose the lies. I don't trust a word you say. Everything is always riddled with half-truths and lies, so I'm going to start letting people know the truth. Not, I'm going to kill you, I'm going to hurt you. It's, you lie to me, and your lying to me affects my life. And people need to know that they can't trust what you are going to say. Again, if you look at the entire conversation, you will see that Greg is saying, thanks, just text me when they're ready, please. Hope your day is going well. Boy, that sounds like someone who is out to hurt someone, right? When can I pick up the kids? I hope your day is going well. Greg was not threatening the defendant. Greg's only concern was seeing and caring for his children. The defendant, on the other hand, so go ahead and run your fucking mouth again. Thanks for being an ass about it. Who in that text conversation was more aggressive? It was the defendant, not Greg Rice. Greg Rice had no intention of hurting Meagan Jackson. So the defendant comes up with this scheme that she is going to expose her affair with Christopher Dontell, but she's going to pin it on Greg Rice. So she begins with these text for free messages. One of them included the list of the 4 people who had gone to Florida. That couldn't have come from Greg because he had no idea where she was. He thought she was in Ohio. He certainly didn't know that she was with Christopher Dontell because otherwise that would have come out in the text. So this text came from Meagan Jackson. How else do we know that the defendant is the one who sent these text for free messages? If you look at, there was one IMGBB link that you can make out. This is what pulls up. At the top of that is Christopher Dontell's number, meaning that this is a photo, not even just a capture. This is a photo, someone taking a photo of the defendant's phone and sending that, uploading it to IMGBB and sending it to Erica. Lieutenant Wells showed you that text conversation in the defendant's phone. How would Greg get the defendant's phone in order to take a photo of this text conversation and send it? How would he even know about this text message? And if you read the content of this text message, believe me, it was specifically chosen to hurt Erica the most. Then, when that didn't work, the defendant started this, she sort of upped the ante a little bit. She started talking about a package is going to be coming in the mail. And already she's, again, blaming Greg. Blaming Greg. And let me actually backtrack for 1 minute with the text for free messages. Don't forget that when Erica said to her husband, call her now, and they called the defendant, who did the defendant say was sending those messages? It's got to be Greg. There's no evidence in the record that Greg cared a whit about who the defendant was sleeping with. All he cared about was his kids. But when the text for free text did not work, she begins this campaign about a package coming in the mail. And again, she's blaming Greg. So this is really a win-win situation for her. She's telling Dontell to intercept the package. Okay, well, if he doesn't intercept the package, then number one, it hurts Erica, perhaps drives a bigger wedge in their marriage, but Dontell is going to think that Greg is trying to destroy their marriage. But if Dontell does intercept it, again, there's still that notion in the background, look what Greg is doing. Look what Greg is trying to do to your marriage. So she had started this little campaign about the package on September 28th. And then on September 30th, we see, and I tried to put the exhibit numbers here so you'd be able to reference them if you wanted to. We see on her web searches that she searched for the location of both the UPS store and the FedEx store, or that she was actually at those two locations, further indicating that she is the one who sent the package. Even more telling is the fact that she deleted her search for the location of where the FedEx store is. How many people here have ever gone to the trouble of deleting a search for a location as bland as FedEx? Further evidence that she was trying to frame Greg for sending this package. So Dontell was able to intercept the package, and you may recall that he said, I opened it up, I didn't look a lot at it, I just brought it over to the defendant, but it was photo collages and pictures of text messages. So then we move on to the notepad, the links in the defendant's notepad. Now remember that she started these text messages about the package coming on the 28th. Well, on the 27th, she starts uploading all of these images into IMGBB, setting the stage. And again, notably, October 2nd, she sends that to the trash. But Lieutenant Wells was able to access each one of those IMGBB links, which he was also able to show you were cached in the defendant's phone. Now, these are just some of them. I think it was exhibits 100A through S, right? But if you look at these text conversations with Dontell's number at the top, photo collages, exactly what Dontell saw in the package. And then also, while this is going on, while the defendant is feeding Dontell this pack of lies about Greg is trying to expose the affair. I'm so scared of Greg. We have evidence of, further malice towards the victim, where there was a text message about popping a tire. I'm all for popping a tire now. So the package still doesn't work. Dontell is still married. He's still married to this day. Whether you agree with her decision or not, Erica Dontell did not leave her husband when word of the affair came out. Did not leave her husband when word of the pregnancy came out. Did not leave her husband when he was arrested for murdering his lover's baby daddy. Still has not left him. So the defendant's campaign to destroy that marriage didn't work, but she kept trying. So then we get to the H-Gate email. And if you recall, this H-Gate email, which was sent on October 1st, but there was evidence that the defendant's phone had accessed that account on September 27th with a password that was stored in the keychain of her phone. So she's accessing that email account a full 4 days before this email is sent. And the email is sent, so let's widen the web a little bit here. It's not working that I just send things to Erica Dontell. Now the defendant's including Erica Dontell's sister and father. Maybe this will work. Maybe this will break up the marriage. Again, trying to blame it on Greg, but how is Greg going to get these images? These are all clearly from the defendant's phone. And Lieutenant Wells told you that he found them in the defendant's phone. So while she is saying at every chance she can get, Greg is doing this, Greg is trying to expose the affair, this is all Greg's fault, it is clearly her fault. And when this still doesn't get the desired result, the next step of the plan goes forward. So this email was sent on October 1st. Now we go to October 2nd. And they go to the preserve where they have been on the 29th, the 30th, and now the day of the murder. And they engage in target practice. So on October 2nd, they were together all night. Christopher Dontell told you that, but the evidence tells you that also. As you think through Christopher Dontell's testimony, think of how it's corroborated by phone records, surveillance videos, LPR photos, starting when they left their community, the community that the defendant moved into, knowing that the Dontells already lived there. So they're leaving their community within moments of each other. And the phone activity shows the same thing. They go to the preserve, again for target practice. We see both cars leaving. We saw them coming in as well, but there they are leaving. There are the phone records showing that both phones are hitting off the tower that serves the preserve. Then they go to Abuelo's, seated at the bar together. Again, the phone records show that they were together all night. All the way through to 11:06, 11:07 p.m., the last connection that Greg's phone makes to any tower. We ran the surveillance video for you from Just Ask Hal, or the Lowe's food parking lot. You see the defendant's van and Dontell's Ford Explorer. You see them, you never see Greg. Why? Because he was being stored in the Myrtle Beach Funeral Home cooler. We know that the defendant was the last person to talk to Gregory Rice. Twice. First she calls at 9:45, and then again at 9:58. And at that point, Greg Rice starts walking towards the Clay Pond Road entrance to the Arrowhead community. They leave Arrowhead at the same time. Again, supported by the phone records. And we know what happened during that 6 or 7 minutes in the Arrowhead community. Christopher Dontell testified he was driving the defendant's van. As they're pulling down Arrowhead Boulevard, they see the victim walking down the road. Dontell begins to pull over, and the defendant says, "No, turn around, make a U-turn and pull up in front. Don't be awkward." And then as soon as he pulls up, the defendant jumps out of the car and fires multiple shots, killing Greg Rice. And what's interesting is every single shot is on the left side of the body. So picture this, that the van is in front of me. On Greg Rice, I'm walking up, door opens, I see the defendant hop out with a gun in her hand, and I start turning to run for my life. Shot, 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 shot. He saw it coming. Now, the defense made quite a bit of, well, everyone, like Captain Wilson, did you park in the lot? Did you go to the sidewalk? Did you walk up to the apartment? Did anyone say shots fired? Did you see any crime scene? Focusing first on whether or not there were any calls about shots being fired, I suggest that anyone who has lived in Horry County for any length of time has heard gunshots. And quite frankly, if you called the police every time you heard gunshots, you wouldn't have time for much else. But what you should also consider is where the shots happened. In this, next to this 8-acre tract. And there was testimony, I believe it was by Sergeant Jones, that a shot from a .22 caliber, which is what the murder weapon was, is much softer than, say, a 9mm or a .357 Magnum. But the fact that no one called in shots fired is really of no moment. Again, we go back to the last data connection that we have with Greg Rice's phone. And as you were watching that sort of animated slide, Sergeant Marcus loves these animated slides, puts them in every presentation. But if you looked at that animated slide detailing the last sort of life of Greg Rice's phone, you will notice that Greg's phone is tracking with the defendant. At one point in that animation, it was geolocation data of the defendant with Greg Rice's phone. Christopher Dontell also told you that after they had stored the body in the funeral home, at some point in the evening, the defendant wanted to go back and get some of Greg's belongings so that she could plant them at the apartment and kind of give life to this missing person story. Well, how do we know that that is accurate? Because he told you about a trade embalmer. I learned a lot about the business of death in this case. I never knew that there was a trade embalmer, someone that would show up at a funeral home at midnight to embalm a body, but sure enough, they did. And again, geolocation data shows that the embalmer's wife, Joanne Cusack, was at the Myrtle Beach funeral home at the same time as Meagan Jackson, her geolocation data. And that's at 12:38 at night. So, based on everything that we had seen so far, all the evidence that has been entered, the defendant was charged with murder. Now, typically, the prosecution and the defense fight over just about everything. But I cannot imagine a reasonable argument that Greg Rice was not murdered. Shot a minimum of 5 times and dumped in a river to be found 5 weeks later. So then, what it is up to you to decide is the defendant guilty of the murder? Certainly, by Mr. Dontell's testimony, she is. If you have any hesitation about that, then South Carolina has hand of one, hand of all. If they were acting together, and you heard that he had originally been charged with murder and criminal conspiracy and accessory after the fact, entered a plea with no agreements with the state to criminal conspiracy and accessory after the fact. So if you think, well, maybe Dontell did it and not the defendant, you go back to this hand of one, hand of all, which says that it doesn't matter. Two people can be guilty of killing another when only one of them has a gun and only one of them fires a shot. But I would suggest to you that there should be no question in your mind who fired the multiple shots that killed Greg Rice. Because all you need to do is look at who benefited from his murder. Christopher Dontell and Erica Dontell never met Greg Rice. Never. The news of the affair and the pregnancy was already out. So what benefit would it be to kill Greg Rice? You can't stuff that secret back in the bag. And as I said before, the news of the affair and the pregnancy did not end Dontell's marriage. The defendant is the only one who benefited from Greg's murder, and I think that's evident in the seeds that she planted along the way. In a moment, after defense closing and the judge's charge, you will be asked to render a verdict. Verdict in Latin means to speak the truth, something I would suggest the defendant has an extremely difficult time doing. But it is your job to end the defendant's continued deception and speak the truth and convict her of murder. Thank you.
Defense?
Your Honor.
She's just going to take this down, Your Honor. So
Thank
Good morning. What you're going to hear in the jury charge, in terms of reasonable doubt, you're going to hear reason to hesitate. What you're looking for in this case is a reason to hesitate. And in this case, there are many reasons to hesitate. How about the first one? Every word that was just uttered to you would have been used in a trial to try to convict Chris Dontell of murder. Every single fact you have heard just 7 months ago, and it should scare you, would be used to convict Chris Dontell of murder, not Meagan Jackson. And that should horrify me. So let's look at what you're going to hear. You're going to hear, of course, going to tell you about not holding it against the defendant for not testifying. And take that to heart. It's part of your constitutional right. And think about this for a second. When it comes to who didn't testify, you can't consider Meagan Jackson didn't testify, but you should consider the fact that they never put up the chief investigating officer. He never took a stand. You want to know why? He didn't want to co-sign this. He's ashamed of what this case looks like. Because he knows what I know, which is for you to convict Meagan Jackson, you have to believe Chris Dontell. And that's something nobody should have to do. Let's look at what they actually presented to you. Because once you remove Chris Dontell, what you start to see is there's not a whole lot of evidence of a crime, of an actual crime. They've shown to you Meagan Jackson wanted Chris Dontell to have the courage to go tell his wife about their affair. She wanted him to go tell him. That's not a crime. Now, did she do that in ways that maybe we wouldn't agree with? Sure. But her wanting that marriage, that affair to be outed, that is not a crime. And the fact that they're trying to get you over there and make that the case should tell you they have a lot of weakness in their actual case. An actual case requires them to prove things that happened at the time of the crime, which they can't do. Because for 4 years, they've been telling themselves, and anyone who will listen, that this happened at the Myrtle Beach funeral home. It wasn't until 7 months ago that they started telling you it's Flint Lake Apartments. How can you believe and not hesitate when they have shifted the crime scene 4 years later? Does that make any sense to me? So what did they present? Well, they presented some evidence about where phones were. You got some phone information. Okay? The problem with phone information is this. It doesn't put you in the actual what's going on moment. It doesn't tell you if Meagan Jackson drove Greg Rice alive back to the Myrtle Beach Funeral Home and dropped him off so that he could talk to Chris Dontell. It doesn't tell you she went inside. It doesn't tell you what's actually happening in the moment. And they knew that coming into this case. Do you think it's a coincidence that he wrote a statement out, Chris Dontell did, and hand-delivered it to Ken Marcus, and an hour later, the state has it changed? I mean, he hand-wrote a statement and told the state he did not see it happen. He was not present. He was not there. That is what he told the state. And an hour later, that's changed. Now all of a sudden, he's an eyewitness to it? If that doesn't give you a reason to hesitate, I don't know what else could. I cannot think of something more important than the fact that that man would change his statement within 1 hour to assist the state to try to convict Meagan Jackson. Tell you what that does, it tells you exactly what he's about. He's about Chris Dontell. He's about himself. That's the reason he wouldn't tell Erica. That's the reason he's pushing Meagan. And that's the reason he killed Gregory Rice, because he is about himself. What else did they present? Well, look at some of the other investigators. I have never seen the investigators that took this stand. They looked sad up here. They were ashamed of this. And you should be. I mean, you spent 4 years telling everybody this happened at Myrtle Beach Funeral Home. And the one thing that changes your mind on that is the testimony of Chris Dontell. That's the only piece of evidence that changed what they believe happened that night. Can you count on Chris Dontell? They shuffled up 2 dentists. I don't know why. They shuffled up 2 ballistics people. I don't know why. I'll tell you, I do know why. Because if you don't have real evidence of what happened in terms of the crime, what you do is you expand this trial. You go put a bunch of evidence in, so when you go back there, you go, man, look at all this. But ask yourself as you're looking at it, does any of it actually prove what happened? You can piece it all together, but when you get right down to it, you're always going to have to come back to trusting Chris Dontell. And that's the one thing the state didn't want you to have to do, but they could never get around that. Let's talk about some of the things they clearly missed. They want you to believe that she returned a wallet and keys the following day. You might have heard that. The wallet and keys are sitting right there in evidence. Guess what you don't have to go with those? A DNA sample. You talk about easy. You talk about simple. Send the keys off. Have the DNA checked. Comes back Meagan Jackson, you might have a little something. They didn't do that. Oh. Make sure you look at that blanket or that sheet. They want to tell you that sheet is evidence that Meagan Jackson had that in her van. Remember what they told you about it, though. They told you it looked like it came from the Myrtle Beach Funeral Home. Guess what that evidence was going to look like 4 years ago? 7 months ago. 7 months ago, that evidence was going to be that sheet. That sheet is evidence that Chris Dontell was sitting there in the Myrtle Beach Funeral Home when Meagan Jackson brought Greg Rice there and he killed him. That isn't a Grindstaff. She worked for Grindstaff Transport. That was a Myrtle Beach Funeral Home sheet's what they told you. It's sitting right there with Chris Dontell. The reason they didn't like that is because they could never prove to you, and still haven't to this day, what was going on in her mind. But I think we kind of know. She showed up on October 2nd with what? When they went to the shooting range, what did she have in her car? Blow up Betty. She's still trying to woo Chris Dontell. She got blow up Betty. She's not worried about shooting targets. She's looking to have more sex, and that's what their relationship was about. You can pick any night from the time they started dating, and they are together, they are swapping cars, they're having sex in their car. That's what their relationship was about. And she was true to that on the night of October 2nd. That's what she showed up to do. Do I think she wanted Greg Rice to help her out this affair? I absolutely think she did. Was Greg Rice an imposing guy? Yes, he was. If Greg Rice had a chance to talk to Chris Dontell and tell him, hey man, get your stuff straight, I think he'd have done it. Go tell your wife, I think he'd have done it. And that's what Meagan Jackson wanted him to do. She wanted Greg Rice to help her get Chris Dontell to man up to what was
Objection,
going
Your
on.
Honor. This is all arguing facts, not evidence.
Listen, I'll let her go. Thank you, Your Honor. That's exactly what was going on. That's what they've proven to you, is that she wanted this affair to be outed. That's what they have proven to you. And did she go about it the right way? Maybe not, but she wanted it to be outed. What is also true, when we start talking about motive, her and Greg Rice's relationship, yeah, it's typical ex stuff. They talk a little vulgar to each other, you know, they fight over kids. It's typical marital, ex-marital. There's some nastiness in there. But Greg Rice, having him in her life was a benefit to her. They made a big deal out telling you she's not the best mother. Well, guess what a mother who's struggling needs? Help. Getting rid of Greg Rice gets rid of her help. There is no motive there. But think about Chris Dontell on the other hand. Chris Dontell is getting word that he's about to lose Erica, could be losing Meagan, and that Greg Rice is complicating his life and is going to out his affair. There's a text. If he sees Erica, he's going to tell her. So the only person that actually has a motive, a true motive, to get rid of Greg Rice is Chris Dontell. And can you trust him? Can you trust him? Well, let's consider some reasons why maybe not. Got a little list here. Reasons that you should not trust Chris Dontell. He doesn't even recall his plea. He doesn't even recall his plea. He sat up here 7 months ago, took the plea, or he slithered his way out of the murder charge. He don't remember. His handwritten statement to Marcus. His handwritten statement to Marcus that he changed within 1 hour. That's the second reason. He sat here and told you he was scared of Meagan Jackson and that he's sleeping with her. After this occurs, and he tells you, she did it and I had to watch it, I had to watch it all. He's sleeping with her. Do you think that that's really, can you believe that? No, you can't believe that. How about this, man? He slipped this right by you. The only person who has Greg Rice's blood on them is Chris Dontell. That's it, guys. The case should be over. The only person with blood on their shoe is Chris Dontell. How about this? He tried to tell you that Meagan Jackson went home after this, went from Lowe's, they went home and she showered. She got all changed up. Had to get the blood off of her. Well, guess what? If you saw the surveillance video footage, when they go back to Lowe's, she's wearing the same exact thing she was wearing when she left Lowe's the first time. She hadn't changed her clothes. She was wearing the same black scrubs. Can't trust Chris Dontell. Who disposed of the body? Who disposed of the body? Chris Dontell. Does he strike you as the kind of guy who's going to do you a favor? Is that the guy you want to go to for a favor? He is the most selfish person I've ever seen. He sat up here and told you he disposed of the body as some kind of favor. You ain't buying that. You can't. You know what? He did a lot. I called him Chris Dontell, full of lies and cries. I'll tell you when he wasn't crying. He wasn't crying when he was shopping in Lowe's. Just grabbing cinder blocks and tarps, stick them in his grocery cart, and let's grab the Pepsi. He was mortified about what had happened. He looked pretty casual there to me. I don't know about you. How about that very sweet wife of his who sat up here and remains committed to him after he sent these heartfelt texts about how much he loved her and was going to stay with her after he killed Chris Dontell. He's still sleeping with Meagan Jackson. Can't trust him. How about the fact he's seen sneaking around looking for a key at a Myrtle Beach funeral home? Can't trust him. How about the fact he lies to Meagan Jackson about where he found that key? Can't trust him. How about the fact that blow up Betty is not very good target practice? Not much of a marksman myself, but I'm pretty sure if you shoot an inflated object, it just explodes the one time you shoot it. That would be the worst target practice I've ever heard of. You would want something that would withstand some gunshots. Can't trust it. And if at all you find yourself in some crazy way wanting to trust this man, I don't think you would. If I told you, he's up here testifying, trying to get his plea reduced. That's why he's here. He's here for who? He's here for himself. That's what he's here. I'll tell you something that really makes me not trust the state, frankly. Not just them having people's phones, but what makes me not trust the state. How about how they're doing you with Chris Dontell? When it suits them, he's their buddy. Hand of one is the hand of all. Meagan Jackson, Chris Dontell's hands, they'll tell you we're in the cookie jar together. Well, then he takes a plea. His plea makes it impossible for him to be charged with murder. The state took his hand out of the jar. Here's what's wicked, man. Here is so wicked. And they bring him back up here and let him testify in a way where they're going to ask you to consider the hand of one and the hand of all. So what are they going to do? They're going to stick it back in the jar. When it suits them, they're going to stick it back in the jar. And as soon as we leave here, they take it right back out. That's crooked. See what else they're going to do? They're going to ask you to believe a man they don't believe. They're asking you to trust Chris Dontell, and they don't trust him. You know why this conspiracy charge is gone? The court decided that not enough evidence to support the conspiracy charge, you no longer have it.
Objection, Your Honor.
This day,
Move to strike.
I strike that. That's a matter of law.
When it comes down to the hand of one is the hand of all, that is there. And I knew it in the opening statement, from the ringing bell, I knew it. We were in for a wild ride, because when you're trying to count on that to prove somebody guilty of murder, you know you have a weak case. You know you do, man. If you can't put Meagan Jackson on the scene, of course they don't have a scene here, you know your case is weak. I'll tell you what really worries me. It's not that they don't trust Chris Dontell. I mean, I know they don't trust Chris Dontell. You don't trust Chris Dontell. But what I find offensive about their position is they don't trust you. They don't trust you. Because if they trusted you, they would tell you that the case we put up here, the case we put up as the state, banks on Chris Dontell telling you she just jumped out and started shooting. I had no idea what was going to happen. That's what he told you. That is their case. That's evidence they put into the record. But now they want you to just bypass some of that. Wicked stuff. So what happened? Mr. Britton, give us some theories. Well, here's the evidence in the record. Pretty simple. You can consider reverse truth. Very common. Co-defendant will strike up here, testify against their defendant, and tell you exactly what they did and put it on the other person. Meagan Jackson, sitting in the car with Chris Dontell, they pull up, Chris Dontell gets out and starts shooting. And she had no idea he was going to do it. And that is, you can believe that all day long. That is as likely, and when it comes to motive, much more likely than the fact that Meagan Jackson would get rid of her father, or the father of her children. But that's really not what this case, in my opinion, look, when you look at Flint Lake Apartments as a crime scene, it kind of falls apart. I don't know. I mean, they have a witness who tells you gunshots are fired there all the time. I don't know. Maybe you believe that. Maybe you don't. I find that pretty hard to believe. I find it hard to believe that when they're out there 9 times, nobody says, okay, listen, I'm going to tell you, we got gunshots out here all the time. I heard some, but I didn't say anything to you the first 4 times you were here because I didn't think it was all that important. Because we just, we don't ever report it. I find that extremely hard to believe. I find it hard to believe that they claim she's out there picking up evidence the next day and nobody sees that either, in broad daylight, with her kids running around. That don't make any sense to me. That don't make any sense to me. And it didn't to them either. So you should not feel bad about that. If that does not make sense to you, you should feel good with that. Because it doesn't make any sense. And that's why the state didn't believe it. and that's why the chief investigating officer didn't testify, is because their original position on this is probably what happened. And then you can read into the evidence. She goes and she picks him up, and she gets him to the Monroe Beach Funeral Home alive. And their problem is they can't tell you what happened after that. They can't blame her. And since the snake has already slithered out of the room, they can't blame him. But I can promise you, as soon as once you make that decision, Flint Lake Apartments is an unlikely spot. You have your reasons to hesitate, and the rest of this case falls at Monroe Beach Funeral Home, where they themselves believe it falls. Dave, the court's indulgence for a second, Your Honor.
All right.
Just in closing, I would just say, when you get back there, what you really follow the court's instructions, but just ask yourself at the end of the day, do you trust Chris Dontell? Because the only way you can convict her is if you trust that man. And I don't think you can. Thank you.
All right, ladies and gentlemen, all of the evidence in this case has been presented to you. The attorneys have made their closing arguments, and now is the time of the trial when I charge you with the law to be applied in this case. The indictment in this case charges the defendant with murder. The court has already dealt with the indictment charging the defendant with conspiracy to commit murder, so you need not consider that charge in your deliberations. I remind you that the fact that the defendant was arrested, charged, and indicted in this case is not evidence in this case. It cannot be considered by you as evidence of guilt in this case. Nor does the defendant's arrest, charge, or indictment create any presumption or inference of guilt. This document is simply the formal written instrument which contains the charge made against the defendant. It is the formal document by which this case is brought into this court. The defendant pleads not guilty to this indictment. That plea puts the burden on the state to prove the defendant guilty. A person charged with committing a criminal offense in South Carolina is never required to prove her innocence. I charge you that an important rule of the law is that the defendant in a criminal trial, no matter what the seriousness of the charge may be, will always be presumed to be innocent of the crime for which the indictment was issued, unless guilt has been proven by evidence satisfying you of that guilt beyond a reasonable doubt. This presumption of innocence does not end when you begin your deliberations, but it accompanies the defendant throughout the trial until you reach a verdict of guilt based on evidence satisfying you of that guilt beyond a reasonable doubt. The presumption of innocence is like a robe of righteousness placed about the shoulders of the defendant, which remains with the defendant until it has been stripped from the defendant by evidence satisfying you of the defendant's guilt beyond a reasonable doubt. The presumption of innocence is not a mere legal theory. It is not just a legal phrase. It is a substantial right to which every defendant is entitled unless you, the jury, are satisfied from the evidence of the defendant's guilt beyond a reasonable doubt. Now, what is a reasonable doubt in the law? A reasonable doubt is the kind of doubt that would cause a reasonable person to hesitate to act. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. We know very few things in this world with absolute certainty, and in criminal cases, the law does not require proof that overcomes every possible doubt. If based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, you must find the defendant guilty. If, on the other hand, you think a real possibility exists that the defendant is not guilty, you must give the defendant the benefit of that doubt and find her not guilty. I remind you that during this trial, you and I have certain duties to perform. As the trial judge, my responsibility is to preside over the trial of this case. I also have the duty to rule on the admissibility of the evidence offered during this trial. You are to consider only the competent evidence before you. If any testimony was ordered stricken from the record in this case during this trial, you must disregard that testimony. You are to consider only the testimony which has been presented for the the witness stand, any exhibits which have been made a part of the record in this case, and any stipulations of counsel. I have the additional duty to charge you the law applicable to this case. As the presiding judge, I am the sole judge of the law of this case. Your duty as jurors is to accept and apply the law as I now stated to you. If you have any ideas to what the law is or what the law ought to be, and your idea is different from what I now tell you the law is, you must disregard your idea of what the law is or ought to be, because you are sworn to accept the law and apply the law exactly as I stated to you. In every case tried in this court before a jury, the jury is the sole and exclusive judge of the facts in the case. A trial judge cannot intimate, state, comment on, or make any statement to a trial jury about the facts in a case. Since you, the jury, are the sole judge of the facts in this case, you're not to infer from what I have said during the progress of this trial in ruling upon the admissibility of evidence or otherwise, or anything that I say now during the course of this instruction to you, that I have any opinion about the facts in this case. The law does not allow me to have an opinion about the facts in this case. This is a matter solely for you, the jury, to determine. As jurors, your duty is to determine the effect, value, weight, and truth of the evidence presented during this trial. Two types of evidence are generally presented during a trial: direct evidence and circumstantial evidence. Direct evidence is evidence that directly proves the existence of a fact and does not require deduction. For example, direct evidence is the testimony of a person who claims to have actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is proof of a chain of facts and circumstances indicating the existence of a fact. Crimes may be proven by circumstantial evidence. The law makes no distinction between the weight or value to be given to either direct or circumstantial evidence. Nor is a greater degree of certainty required of circumstantial evidence than of direct evidence. However, to the extent the state relies on circumstantial evidence, the circumstances must be consistent with each other, and when taken together, point conclusively to the guilt of the accused beyond a reasonable doubt. If these circumstances merely portray the defendant's behavior as suspicious, the proof has failed. You should weigh all of the evidence in this case. After weighing all the evidence, if you are convinced of the defendant's guilt beyond a reasonable doubt, you must find the defendant guilty. On the other hand, after weighing all of the evidence, if you are not convinced of the guilt of the defendant beyond a reasonable doubt, you must find the defendant not guilty. The state has the burden of proving the defendant guilty beyond a reasonable doubt. This burden rests with the state regardless of whether the state relies on direct evidence, circumstantial evidence, or some combination of the two. Necessarily, you must determine the credibility of witnesses who have testified in this case. Credibility simply means believability. Your duty as jurors is to analyze and to evaluate the evidence and determine which evidence convinces you of its truth. In determining the believability of witnesses who have testified in this case, you may believe one witness over several witnesses, or several witnesses over one witness. You may believe a part of the testimony of a witness and reject the remaining part of the testimony of that same witness. You may believe the testimony of a witness in its entirety, or reject the testimony of a witness in its entirety. You may consider whether any witness has exhibited to you any interest, bias, prejudice, or other motive in this case. You may also consider the appearance and manner of the witness while on the witness stand. Evidence has been presented that a witness has made prior statements which are not consistent with the witness's present testimony. You may use this evidence to decide whether to believe the witness. You may also use evidence of the earlier contradictory statements to determine the truth of those statements. You must decide whether to believe the earlier statements or the testimony given at trial. If a witness is shown to have knowingly testified untruthfully concerning any material matter, you may consider this in determining whether to trust the witness's testimony as to other matters. You may reject all of the testimony of that witness, or give all or a part of the testimony the weight you think it deserves. Rules of evidence ordinarily do not permit witnesses to testify to opinions or conclusions. An exception to this rule exists for witnesses we call expert witnesses. A witness who by education and experience has become expert in some art, science, profession, or calling may state an opinion as to the relevant and material matter in which the witness claims to be an expert, and may also state the reasons for the opinion. You should consider any expert opinion received in evidence in this case, and like any other evidence, give it the weight you think it deserves. If you decide that the opinion of an expert witness is not based on sufficient education and experience, or if you conclude that the reasons given in support of the opinion are not sound, or that the opinion is outweighed by other evidence, you may disregard the opinion entirely. An expert witness's testimony is to be given no greater weight than that of other witnesses simply because the witness is an expert. Further, you're not required to accept an expert's opinion even though it is not contradicted. I instruct you and emphasize that the fact the defendant did not testify is not a factor to be considered by you in any way in your deliberation and in your consideration on the question of the guilt or the innocence of the defendant. The defendant's decision not to testify must not be considered by you in any manner whatsoever. A defendant has the constitutional right to remain silent, and the assertion of this right must not be considered by you in your deliberations. I repeat, under your oath, you are to draw no conclusion whatsoever from the fact that the defendant in this case did not testify. The fact that the defendant did not testify should not even be discussed in the jury room. The burden of proof, as I have stated to you, is on the state. The defendant is not required to prove her innocence. The burden of proof remains on the state to prove guilt beyond a reasonable doubt. In order to establish criminal liability, criminal intent is required. For example, the mental state required to be proven by the state for a particular crime might be purpose, intent, knowledge, recklessness, or criminal negligence. Criminal intent must be proven by the state beyond a reasonable doubt. Criminal intent is always a matter that must be determined by the jury from the circumstances surrounding the situation. Criminal intent cannot be proven to a mathematical certainty. Medical science cannot dissect a person's brain and determine what the person had in mind. So the law says that criminal intent may be inferred from the circumstances shown to have existed. This is how you make a determination of whether or not the element requiring intent is present. Criminal intent does not have to be established by direct and positive evidence. Intent may be established by inference in the same way as any other fact, by taking into consideration the acts of the parties and all the facts and circumstances of the case. Criminal intent is a mental state, a conscious wrongdoing. You must determine what the defendant intended to do based on the circumstances shown to have existed. Criminal intent can arise from an action or a failure to act. It may arise from negligence, recklessness, or an indifference to duty, or to consequences that is considered by the law to be the equivalent of criminal intent. Now, the defendant is charged with murder. To convict the defendant of murder, the state must prove beyond a reasonable doubt that the defendant killed another person with malice or forethought. Malice is hatred, ill will, or hostility towards another person. It is the intentional doing of a wrongful act without just cause or excuse, and with an intent to inflict an injury, or under circumstances that the law will infer an evil intent. Malice or forethought does not require that malice exists for any particular time before the act is committed, but malice must exist in the mind of the defendant just before and at the time of the act is committed. Therefore, a combination of the previous evil intent and the act is required. Malice or forethought may be expressed or inferred. These terms, express and inferred, do not mean different kinds of malice, but merely the manner in which malice may be shown to exist, either by direct evidence or by inference from the facts and circumstances which are proved. Express malice is shown when a person speaks words which express hatred or ill will for another, or when the person prepared beforehand to do the act which was later accomplished. For example, lying in wait for a person, or any other acts of preparation going to show that the deed was within the defendant's mind would be express malice. Malice may be inferred from conduct showing a total disregard for human life. If facts are proved beyond a reasonable doubt sufficient to raise an inference of malice to your satisfaction, this inference would be simply an evidentiary fact to be considered by you, along with the other evidence in the case. You may give it the weight you decide it should receive. If a crime is committed by two or more people who are acting together in committing a crime, the act of one is the act of all. A person who joins with another to commit an unlawful act is criminally responsible for everything done by the other person, which happens as a probable or natural consequence of the acts done in carrying out the common plan and purpose. For example, two people can be guilty of bank robbery when only one of the two enters the bank and takes money from the cashier, while the other acts as a lookout in the getaway car. If two or more people are together, acting together, assisting each other in committing the offense, the act of one is the act, or is the act of all, or as it is sometimes said, the hand of one is the hand of all. Prior knowledge that a crime is going to be committed without more is not sufficient to make a person guilty of that crime. Mere knowledge that another person is going to commit a crime, even if the defendant is present when the crime is committed, is not sufficient to convict the defendant as a principal. Guilt as a principle is shown by actual or constructive presence at the scene as a result of a prior arrangement. Therefore, a finding of a prior arranged plan or scheme is necessary for a finding of guilt as a principle. The state must prove beyond a reasonable doubt by competent evidence the theory of the hand of one is the hand of all. A principal in a crime is one who either actually commits the crime or who is present, aiding, abetting, or assisting in committing the crime. When a person doesn't act in the presence of and with the assistance of another, the act is done by both. Where two or more acting with a common plan or intent are present at the commission of a crime, it does not matter who actually commits the crime. All are guilty. The hand of one is the hand of all. Present at the commission of a crime means to be sufficiently near to aid and abet and assist in the commission of the crime. However, mere presence at the scene of a crime is not sufficient to convict one as a principal on the theory of aiding and abetting. Intent is also a necessary element, for there must have been a common design or intent to commit the crime, and the crime must have been committed pursuant thereto, with the person aiding and abetting by some overt act. Intent means intending the result which actually occurs, not accidentally or involuntarily. Intent may be shown by acts and conduct of the defendant and other circumstances for which you may naturally and reasonably infer intent. The state must prove these elements beyond a reasonable doubt. Now, ladies and gentlemen, you may find one of two possible verdicts in this case. No significance is to be given to the order in which I state these verdicts to you. I simply have to state one first and one second. The possible verdicts in this case are either guilty or not guilty. Ladies and gentlemen, your verdict must be a unanimous one. Mr. Roberts, as foreperson, when the jury agrees on the verdict, you will write the verdict here under the verdict portion of the indictment. Then you'll sign your name as foreperson and date the indictment, and then knock on the door and tell the bailiff you have reached a verdict, and we'll bring you back into the courtroom at that time. Now, you have been allowed to take notes during the trial of this case if you wanted to. And I will now allow you to take your notes with you into the jury room while you deliberate on your verdict. However, note-taking is not required. Please remember that some people are better note-takers than others. Juror notes should not be given any greater weight than the recollection of other jurors. The recollections of individual jurors should be considered as reliable as notes taken by any other jurors. Now, I'm going to excuse you to the jury room in just a minute, but I'm going to tell you, don't begin your deliberations. I need to check with the attorneys to see if they have any additional charges or corrections to the charges I've given you. If they do, and I deem them appropriate, I'll bring you back into the courtroom and make whatever corrections or additional charges are needed. If there are none, the exhibits will be brought back to the jury room and the bailiff will instruct you to begin your deliberations. But do not begin your deliberations until you're instructed to do so by the bailiff. Also, we have ordered lunch for you. It hasn't gotten here yet, but it should come shortly. When lunch gets here, you can do one of two things. You can stop your deliberations, eat your lunch, and then resume deliberations after you eat lunch. Or if you prefer, you can deliberate while you eat lunch. The only requirement is that everybody must do the same thing. You can't have some jurors stop deliberations while other jurors continue to deliberate. But whatever you choose to do, whether you deliberate while you eat, or if you want to take a break, you can do that as well. All right, I'm going to excuse you back to the jury room, but please do not begin your deliberations until you're told to do so by the bailiff. Thank you very much. All right, any exceptions or challenges to the charges by the state?
None from the state, Your Honor.
All right, any by the defense?
Just a reiteration of our objections to the hand of one and the hand of all, Your Honor.
All right, I'm going to go ahead and leave that in place and state my prior reading.
Thank you, Your Honor.
Thank you. Anything else from the defense?
Yes, sir, Your Honor.
Can we,
I'm sorry.
go somewhere where we're 5 minutes away?
Right. If you want to leave, make sure clerk of court has your, or my law clerk of court has your number where you can be reached. Okay?
Yes, sir, Your Honor.
All right. Let's make sure we have all of the exhibits
Yes, Your Honor.
right here. Also, if you would go ahead and bring the alternates, and that would be Mr.
Your Honor, with the court's permission, I'm going to take this to my table and just go through and pull out the ones that were not admitted.
I wrote it down.
Yes, sir.
There you go.
So,
That's the number.
thank you. Ladies and gentlemen, this is the part of the trial I hate, because the law says that since we still have our 12 jurors, it does not allow the alternates to participate in the deliberation. I hate that because we make you sit through the whole trial just like regular jurors, but then we don't let you make a decision. I want to thank you for your service. That'll conclude your service for this term of court and for this trial. You're at liberty to do whatever you want to do. If you want to stay and see the outcome, you can do that. We've got lunch coming. If you want to stay and eat lunch, you can do that. If you want to leave now, you can do that. If you want to stay a while and then leave, whatever you want to do. We just cannot let you deliberate with the other jurors. Does anybody have anything in the jury room they need to get?
Yeah.
Okay. Please let the bailiff know what it is you need to get, and they'll go in and they'll get it for you. Well, no, we haven't sent the exhibits back. So just go with them, and they can go in and get whatever you want. Come back out. They'll have a place. If you want to stay, you can stay. If you want to leave, you want to leave. If you want to eat, whatever, you can do that. Thank you for your service. You've got a 1-year disqualification from serving jury duty. You've got a 3-year exemption. I hope you don't exercise your exemption, because we do need our good jurors, and I want to thank you for that. As I said, you're free to go, stay, whatever you prefer to do. All right, thank you very much. back to the jury, and you can tell them they can begin their deliberations.
And Your Honor, the jury laptop is here if they need it for any reason.
Okay. That'll be good. Thank you. All right, anything from the state before we recess?
No, Your Honor.
Anything from the defense?
No, sir, Your Honor.
All right, we'll be in recess until we hear from the jury.
Thank you, Your Honor.
May I approach?
Yes. we got the question in from the jury. It says, what classifies as hand of one, hand of all? What are the parameters? Does just being present at the scene of a crime classify as hand of one, hand of all? All I know to do is to just bring them back in and recharge them on the hand of one as the hand of all. And we'll go forward with that. Let's mark this as
Court's
Court's
number.
Exhibit 3. All right. All right, anything from the state before we bring the jury in?
Nothing for the state, Your Honor.
Anything from the defense?
Your Honor, I'm concerned about this charge. You know, last time you gave me 2 charges that dealt with the agreement. So I can't recall if that's in the hand of one or hand of all, but I believe the required plan or scheme needs to be in your charge. So
Well, and I think it is in there. As I recall, my hand of one is hand of all. I mean, this isn't the entire charge, but I think the part you're referencing to,
I believe it's on page 15, Your Honor.
yeah. Yeah, prior knowledge that a crime is going to be committed without more is not sufficient to make a person guilty of that crime. Mere knowledge that another person is going to commit a crime, even if the defendant is present when the crime is committed, is not sufficient to convict the defendant as a principal. Guilt as a principal is shown by actual constructive presence at the scene as a result of a prior arrangement. Therefore, a finding of a prior arranged plan or common scheme is necessary for a finding of guilt as a principal. State must prove beyond a reasonable doubt by competent evidence the theory of hand of one is hand of all. And then later on in the charge, present at the commission of a crime, mere presence at the scene of a crime is not sufficient to convict one as a principal on the theory of aiding and abetting.
Your Honor, I believe the question, it entails the mere presence. I believe that the jury's question entails the mere presence. If they needed further explanation on that, Your Honor, seems good for you to, about that as well.
Well, if that's all they asked, but they asked what were the parameters.
Yes, sir,
They
Your
don't
Honor.
lie, and then they went on to say it's mere presence.
Yes, sir, Your Honor.
So, you know, if they had just said it's mere presence, then I would have said,
Yes, sir,
I'm just
Your
going to charge them on the entire thing.
Yes, sir. Thank you, Your Honor.
All right, let's bring the jury in. All right, ladies and gentlemen, welcome back. I understand the jury had a question on the law regarding the hand of one is the hand of all. So what I'm going to do is recharge you on that issue. as it answers, the jury charges answers your questions, and I think will provide the answer you're looking for. If a crime is committed by two or more people who are acting together and committing a crime, the act of one is the act of all. A person who joins with another to commit an unlawful act is criminally responsible for everything done by the other person, which happens as a probable or natural consequence of the acts done in carrying out the common plan and purpose. For example, two people can be guilty of bank robbery when only one of the two enters the bank and takes money from the cashier, while the other acts as a lookout in the getaway car. If two or more people are together, acting together, assisting each other in committing the offense, the act of one is the act of all, or as it is sometimes said, the hand of one is the hand of all. Prior knowledge that a crime is going to be committed without more is not sufficient to make a person guilty of that crime. Mere knowledge that another person is going to commit a crime, even if the defendant is present when the crime is committed, is not sufficient to convict the defendant as a principal. Guilt as a principal is shown by actual or constructive presence at the scene as a result of a prior arrangement. Therefore, a finding of a prior arranged plan or common scheme is necessary for a finding of guilt as a principal. The state must prove beyond a reasonable doubt by competent evidence the theory of the hand of one is the hand of all. A principal in a crime is one who either actually commits the crime or who is present, aiding, abetting, or assisting in committing the crime. When a person doesn't act in the presence of and with the assistance of another, the act is done by both. Where two or more acting with a common plan or intent are present at the commission of a crime, it does not matter who actually commits the crime. All are guilty. The hand of one is the hand of all. Present at the commission of a crime means to be sufficiently near to aid and abet and assist in the commission of the crime. However, mere presence at the scene of a crime is not sufficient to convict one as a principal on the theory of aiding and abetting. Intent is also a necessary element, for there must have been a common design or intent to commit the crime, and the crime must have been committed pursuant thereto, with the person aiding and abetting by some overt act. Intent means intending the result which actually occurs, not accidentally or involuntarily. Intent may be shown by acts and conduct of the defendant and other circumstances from which you may naturally and reasonably infer intent. The state must prove these elements beyond a reasonable doubt. All right, I'm going to ask that you return to the jury room and continue with your deliberations. All right, anything from the state before we recess?
Nothing from the state, Your Honor.
Anything from the defense?
Yes, sir, Your Honor.
All right, we'll be in recess until we hear back from the jury. very much. Please be seated.
Just waiting for the
gentlemen, I've been informed that the jury has reached a verdict. Anything from the state before we bring the jury in?
Nothing from the state, Your Honor.
Anything from the defense?
Nothing from the defense, Your Honor.
All right, ladies and gentlemen, those of you who are with us, I give this instruction every time before the jury comes in. And that is simply to let you know that we cannot have any type of outburst or anything of that nature, regardless of what the verdict is. This is just simply to let you know that if you're unable to contain your emotions, you need to excuse yourself from the courtroom now. Because regardless of what the verdict is, there's to be no display or no outburst or any sign of emotion whatsoever. All right, so if you need to be excused, you can go ahead and excuse yourself now. All right, let's go ahead and bring the jury in. Ladies and gentlemen, welcome back. I understand the jury's reached a verdict, is that correct? All right, and have you written the verdict on the indictment, signed it as the foreperson, and dated it?
Yes.
All right, if you would please hand it to the bailiff. All right, I'll ask the clerk if she would please publish the verdict.
Indictment number 2021 GS 2601191. The State of South Carolina, County of Horry versus Meagan Marie Jackson as to the charge of murder. We, the jury, by unanimous consent, find this defendant guilty. Signed by foreperson Jeffrey Roberts, dated June 17, 2025. Ladies and gentlemen of the jury, if this is your verdict, please so signify by raising your right hand. Thank you.
Well, let the record reflect that all jurors raised their right hand. Any polling of the jury by the defense?
No, sir.
All right. All right, ladies and gentlemen, I want to thank you for your service. That will conclude your duties as jurors in this case and for this term of court. And I want to thank you for your service. I know jury duty is not a fun thing to do, but it is an important thing to do and a vital thing to do. You have a 1-year disqualification from serving as jurors in state circuit court. You've got a 3-year exemption. I hope you don't exercise your exemption because we do need good jurors. And I want to thank you for your service. You're free to go at this time if you want to go. If you want to stay until the conclusion of the proceedings, you can do that as well. Just remain in the jury box. So it's up to you as to those of you who wish to go ahead and leave now, you can leave now. Thank you very much. All right, anything before we impose sentence?
No, Your Honor.
Well, first, I guess at this point in time, I know the rules of criminal procedure do allow time periods for post-trial motions. Is there any post-trial motions at this time?
Your Honor, we move for a judgment NOV by you based on the adequacy of the evidence presented, and also that you impose a verdict as 13th juror. Having sat through the trial, heard the evidence, we make those two motions. And we would like a little time to flesh those out if possible.
All right, well, I'm going to deny both motions for judgment NOV, and Also, the motion is the 13th juror. I think there's sufficient evidence presented to the jury that supports their verdict. As I said, the rules of criminal procedure do give you time periods to file post-trial motions, so I'll entertain any other post-trial motions you want to do pursuant to those rules. I'll give you that time. All right, anything further at this time?
Your Honor, we are printing the sentencing sheet. We do have two victims who would like to address the court. Savannah Rice, who has been present the whole time, and then Zachary Rice, who is the victim's son from another relationship. With the court's permission, that would be via WebEx because he's had help.
No,
No?
I'm not doing WebEx.
Okay.
All right, so once we get the sentencing sheet, I will give the victims who are present an opportunity to speak if they wish.
I believe Ms. Rice wants me to read her statement.
Well, I mean, we're not doing that right now.
No, I
I need
know.
the sentencing sheet. I'll let you know when I want to hear from the victims.
She just went back to records to get it, Your Honor.
All right.
Your Honor, I believe that Zachary Rice is emailing a statement that he must have already had prepared. So with the court's permission, I'll read that one as well. He's a statutory victim, Your Honor.
Yeah, but why isn't he here? He has the right to be here if he's not here.
Because he was forced to take custody of the children when their father was killed, and he has had to struggle to find jobs to now all of a sudden care for extra children.
All right, anything in mitigation from the defense?
No, we asked that she be given credit for the time that she was in jail off of her sons and credit for home detention. I don't have the exact figure, but I'd like to present that to you in our post-trial motion.
All right. Ms. Jackson, anything you want to say, or does anybody want to speak on your behalf?
Your Honor, she wishes not to speak.
All right. Any prior record?
No, Your Honor.
All right, I'll hear from victims at this time.
And Your Honor, did you need me to address the issue of home detention or not?
No, I'm not.
Your Honor, this is from Zachary Rice, who is the older son of Gregory Rice. At the time, once Gregory Rice was killed, Zachary Rice took custody of the 4 half-siblings. And he did this fairly quickly since we did not have WebEx available to him. He says 5 lives completely shattered, showed no remorse, waited 5 years for this, just celebrated Father's Day without him again. I would like the maximum in sentencing, took my father's life, and I want her to pay eye for an eye and lose hers. And then, Your Honor, if I can have Ms. Savannah Rice come up. Your Honor, she's understandably emotional. She says, Your Honor, I believe that my opinion for how long she should be sentenced does not reflect what has already been done. This crime has torn apart my family, others' families, and friends beyond any measure. My siblings and I have all suffered greatly, not only from the loss of my father, but the loss of a mother too, the loss of our lives. We have been waiting so many years for just a bit of closure, and this is it. We will never have the chance to freely live our lives without the thoughts of what has been done following behind us. It has become a challenge to rebuild and grow from everything that happened. There are still days where I just cry and wish I could go back in time to maybe prevent what happened. I can't do that though, and I will forever have the thought that I can't change anything alongside me. This trial and getting up on the stand has been one of the most heartbreaking and painful things I've ever had to do. It has also been one of the most relieving and rewarding things. I finally got to say what has been sitting in my brain the last 4.5 years. It was a relief finally being able to tell the truth and to go towards a cause. I believe that 50 years to life would be a sufficient amount of time. I thank you for your time, for listening to what I had to say. Thank you. Does Your Honor wish the state to address sentencing?
Well, if there's anything you want to put on the record.
Your Honor, the state is asking for the maximum term of life imprisonment. We believe that there is clear evidence that this defendant not only plotted and planned this murder, but also tried to frame the victim for things that she was doing. As Savannah said, and as I said in explaining why Zach couldn't be here, this really did destroy a number of lives. Zach was forced to take in 4 children, his half-siblings, as a result of them being EPC'd after Meagan Jackson was arrested. We believe that there was nothing short of life in prison that would address this crime.
All right, Ms. Jackson, you have been found guilty of murder by a jury of your peers. The sentence of the court, I agree with the state. The sentence of the court is that you be committed to the Department of Corrections for the remainder of your life. You'll get credit for any time, sir. All right.
Thank you, Your Honor.
Thank you. All right, anything further from the state?
Nothing from the state, Your Honor.
All right, court is adjourned. Thank you very much.
Thank you.